Alright, 605.05.01, nature of transferable interest. Transferable interest is personal property. 605.05.02, transferable interest subject. 605.05.03, in whole and in part of the transferable interest is permissible, does not in itself make a cause of members' dissociation, dissolution, winding up with the limited liability company activities and affairs, does not entitle the transferee to participate in management conduct of the company's articles and affairs, except for the otherwise provided in subsection 3, the access to records and other information concerning the company activities and affairs. The transfer has the right to receive in accordance with the transfer distribution, and the transfer would otherwise entitle the dissolution, winding up with the limited liability company transfer interest entitled to an account of the company's transaction only with the data of the dissolution. The transfer interest must be in evidence of this by a certificate of interest issued by the limited liability company as required of the subject of this section. Interest represented in the certificate may transfer the transfer certificate. Limited liability company cannot need not to give the transfer rights under this section under the company notice and notice for the transfer. Transfer to the transfer interest violation restriction. The transfer contained with the operating arrangement effective with the person has knowledge and notice of the restriction of the time of the transfer, except for the otherwise provided by the member of the transferable interest transfer retains the rights of the manner other transferable interest transfer retains all duties and obligations of the member. If the member in transfer interest of the person who becomes the member with respect to the transferred interest, the transfer liable the member the obligation under 605.04.03, 605.04.06, which denotes the transfer at the time the transfer becomes a member. 605.05.03 charging order. And on the application of the court of the competent jurisdiction judgment, the creditor or the member of the transferee, the court may enter the charging order against the transferable interest of the member of the transfer payment of the unsatisfied amount of the judgment of the interest, except for the divided in subsection 5 of the charging order constitutes the line of the judgment. The debtor transferring interest requires the limited liability company to pay over the judgment creditor a distribution that would be otherwise paid to the judgment debtor. This chapter does not deprive the member of the transferee of the benefit and exemption of law or other transferable interest of the member of the transferee, as except for the provided in subsection 4 and 5. The charging order is sole exclusive remedy of judgment creditor. The member's transferee may justify judgment of the judgment debtor's interest of the limited liability company the right of the distribution from the limited liability company. 4. In the case of the limited liability company has only one member, the judgment of the creditor or the member transfer establishment of the satisfaction of the court of the competent jurisdiction of that to the distribution under the charging order will not justify the judgment with the reasonable time. The charging order is not solely exclusive remedy with the judgment. Creditor may satisfy the judgment against the judgment debtor, which sole the member of the limited liability of the transfer of the sole per member upon such showing of the court of the member other order the sale of the interest limited liability company the pursuant of the foreclosure judgment creditor may show that the court of the distribution under the charging order will not satisfy the judgment with reasonable time after the time of the entry. The judgment may do so that at the same time the judgment creditor applies the entry of the charging order. 5. A limited liability company has more than one member. The court orders of foreclosure sale of the judgment debtor's interest in limited liability charging order lien against the sole member of the limited liability company pursuant to subsection 4. A purchase of the court-ordered foreclosure sale obtains the member's entire limited liability company interest, no merely the rights of transferee. B. The purchase of the sale becomes the member of the limited liability company. The person whose limited liability company interest is sold the pursuant to the sale close the sale of the subject foreclosed and changing the order cases ceases to be the member of the limited liability company. 6. In the case of limited liability company, the more than one member of the remedy of the foreclosure judgment debtor's interest of the limited liability company against the rights to distribution of the limited liability company is not available to the judgment creditor attempting to satisfy the judgment may not be ordered by court. This section does not limit to the following: the rights of the creditor who has been granted the consensual security interest of the limited liability company interest to pursue the remedies available to the secured creditor under the law applicable secured credits. The principle of law equity which affect the fraudulent transfer, the available the equalitability principle with alter ego equitable lien or constructive trust, the other equitable principles not inconsistent with this section. D. This continuing jurisdiction of the court of enforcing the charging order remain consistently in the section 605-0504 power of legal representative. If the member of the individual dies of the court of the competent jurisdiction and judge of the member, then competent the member's persons or property, the member's legal representative may exercise all members the rights to the power of settling the member's estate is administering the member's property, including any power of the member that had been given the transfer of the right of the becoming of the member. If a member of the corporation, trust, or other entity dissolved, terminated, the power may be exercised in legal representative. 605-0601, power to dissociate a member, wrongful dissociation. A person who has power to dissociate a member at any time, rightfully, wrongfully, by withdrawing as a member that expressed it, will be under 605-0602. The person dissociation of a member is wrongfully under only dissociation is in a breach of express provisions. The operating agreement occurs at the completion of the winding up of the company, and the person who withdraws as a member expresses it will. The person expelled for the member judicial under the 605-0602. The person is associated with 605-0602-8. And in case of the person is not in trust with a business trust and in state of the individual, the person expelled otherwise dissociated with the member because it is willfully dissolved or terminated. A person who is wrongfully dissociated with the member is liable with a limited liability corporate company as subject 605-0810. 605-0801. The member of the damages caused by the dissociation and liability in addition to each of the obligation and liability member of the company other members. Notwithstanding any of the contrary under the applicable and articles in the operating agreement may provide limited liability company any interest may not assign before the dissolution winding up over and under the limited liability company.